judiciary's own statement of yesterday, 11th April 2026, the ULS is dismayed to learn of the first ever mobile High Court session at Gaba Community Church grounds commencing tomorrow, 13th April 2026. This orchestrated spectacle is not novel. It is a civilian echo of the very constitutional violations the ULS successfully challenged and the Constitutional Court condemned in petition number 2 of 2002, consolidated with petition number 8 of 2002. In that case, 2 UPDF soldiers were arrested, tried by the field court-martial, convicted, sentenced to death, and executed on the same day for the murder of 3 civilians in Kotido district. The proceedings were driven by public outrage and operational necessity. The ULS petitioned that process. The ULS petitioned that the process violated Article 28, which is the right to a fair hearing before an independent and impartial tribunal, adequate time and facilities for preparation of defense, and Article 28 and Article 128 on judicial independence. The Constitutional Court, in its judgment of 5th February 2009, held unequivocally: 1. The Constitution applies in full to every judicial process, including military tribunals. Military courts form part of the judicial system of Uganda and are therefore governed by Article 128 of the Constitution. It is structurally impossible for such tribunals to be independent and impartial, given the current laws which they are constituted and the military structure within which they operate. The right to a fair trial cannot be sacrificed to speed, public emotion, or external direction. Every accused person is entitled to adequate preparation time, an unprejudiced forum, and protection from prejudicial publicity. Even in the heat of public outrage over heinous crimes, the presumption of innocence and the separation of powers must prevail. Justice Luomusic, as he then was, delivered the lead judgment, declaring the field court-martial proceedings unconstitutional, precisely because they subordinated judicial power to executive and situational pressure. The parallels here are stark and damning. Then, as now, a heinous crime inflamed by public sentiment. Then, as now, speedy justice was demanded and delivered outside ordinary safeguards. Then, as now, the tribunal's independence was compromised by the very structure and context created to satisfy that demand.
Here, at the same time, on the same screen, the one which you found him working with him the other day.
If I may just repeat. Then, I am just listing the parallels between the two situations. Then, as now, a heinous crime inflamed public sentiment. Then, as now, speedy justice was demanded and delivered outside ordinary safeguards. Then, as now, the tribunal's independence was compromised by the very structure and context created to satisfy the demand. The only material difference is that in 2002, the violation occurred in a military forum. Today, it is being replicated in a civilian high court session, deliberately relocated to a crime scene at executive behest. The Constitutional Court's reasoning binds with equal force. A mobile court summoned to the churchyard where the victims were mourned, under live cameras and ministerial oversight, cannot satisfy Article 28 or 128 any more than the Kotido Field Court-Martial Code. We condemn this in the strongest terms. The judiciary's conduct, as announced yesterday, represents an unacceptable institutional cover for the most cynical executive interference in 24 years. The judiciary has descended into the political theater. This is unacceptable. The judicial offense. The mobile court as a political theater. The judiciary's communique confirms that on 13th April 2026, Justice Alice Komuhangi Kauka will preside over a mobile high court at the Gaba Community Church grounds to try Christopher Okello Onyum on 4 counts of murder. It brands the sitting historic and invokes legal notice number 1 of 2026. The ULS finds this session unconstitutional, unsafe, and a calculated fraud on the public for the following reasons. The first reason, a court convened by executive fiat, not judicial necessity. The Constitution, operation of mobile courts practice directions authorize mobile sittings only where circumstances so require to enhance justice, to enhance access to justice and efficiency. No such circumstances exist in the instant circumstances. The High Court Criminal Division sits merely 12 kilometers away in Kampala with full infrastructure, security, record-keeping facilities. The sole circumstance that changed between 9th and 11th of April 2026 was the minister's public demand for a community trial. By relocating the High Court to the exact churchyard where the victims were mourned, the judiciary has converted a narrow legal discretion into open political obedience. This is not access to justice. It is access to a minister. The second offense of the judiciary is violation of the right to a fair trial. Under Article 28 of the Constitution, there is a guarantee of a fair hearing before an independent and impartial tribunal. A court deliberately cited at the scene of the alleged infanticide in a churchyard with the regulated access for representatives of the families, religious leaders, and local leaders cannot possibly be impartial. The venue itself functions as evidence. The anticipated crowd as a witness. The church becomes the dock rather than a sanctuary. Article 28 3C guarantees adequate time and facilities for one to prepare their defense. What law library, what consultation rooms or confidential attorney-client spaces exist on open church grounds? The judiciary has taken the accused from a courtroom to a spectacle and labeled it transformation. The third offense by judiciary is the unacceptable obsequiousness and the collapse of judicial independence. Article 128 declares that in the exercise of judicial power, the courts shall be independent. Article 128.2 commands that no person or authority shall interfere with the courts. The timeline is damning. Minister Balaam issues a directive on 9th of April. ULS condemns it on 10th. Judiciary announces the mobile court in Gaba on 11th. This isn't coincidence. This is command and compliance. The height of cynical interference lies here. The judiciary has allowed the executive to select the venue, the symbolism, the tempo, and the audience of a capital trial, then dressed then dressed the surrender in the language of public interest and the transformational agenda. Mobile courts under Legal Notice number 1 of 2026 were intended for hard-to-reach areas, circuit backlogs, or natural disasters, not for high-profile murders 12 kilometers away from the High Court. To invoke taking justice close to the people in these circumstances is to launder executive interference as judicial reform. The fourth and final, security and decorum. A lynch mob invited by court order. The judiciary's own statement admits particular attention given to security considerations and the categorization system for attendees. While confirming live streaming to a wider audience, the court anticipates rage and therefore rations access and broadcast drama. A trial is not a stadium event. When the judiciary must plan crowd control and overflow screens for a capital murder case, it has already conceded that it is no longer presiding over a judicial proceeding, but managing a flashpoint. We shall say more on this later today and throughout this week. I encourage you to book our officials for press interviews and talk shows and follow through on this discussion here. The statement is signed by the President, Isaac Semakade Chimaze, Senior Counsel, on this Sunday. You want to ask a question?
Counsel, what do you want as the Uganda Law Society?
What do we want as the ULS? Adam, I don't know if we have on call the President. He may want to answer that question there, even if I feel so ready with the answer.
Mr. Nangulu?
Yes, President. There is a question. There is a question from the media. From this statement, they ask.
Well, Mr. Nangulu, thank you very much for delivering my remarks, my prefatory remarks. To clarify the question, stay on the stand, Mr. Nangulu. My remarks are merely prefatory. I am prefacing the position of the bar.
Good afternoon to you, viewers, listeners, people present, colleagues, once again. The name is...
Zander,
yes, Mr. President.
If I may intervene, apologies. I think our Secretariat should give you the written record. I see you're using the...
It is being...
phone record, yeah. Yeah, please. It's very important that you read from the signed record. You may read yesterday's version.
The name is, thank you, Mr. President. The name is Rule Alexander Nkima, the Acting Central Representative, ULS. This is our statement. Statement of position by the Uganda Law Society on the proposed mobile High Court session in Gaba for the trial of Christopher Okello Onyum. It is dated 12th April 2026, and that is today. The Uganda Law Society unequivocally condemns the judiciary's decision to convene the first mobile High Court session in Gaba Community Church grounds on 13th April 2026, that is tomorrow, for the trial of Christopher Okello Onyum, the suspect in the tragic Gaba toddler killings that occurred on 2nd April 2026. That is 10 days ago. Barely a week and a few days. What has been packaged as speedy justice, in quotes, speedy justice and enhanced access to justice, still in quotes, under the Constitution, Operation of Mobile Courts Practice Directions 2026 is in reality the most cynical form of executive interference in the affairs of the judiciary witnessed in Uganda since Constitutional Petition number 2 of 2002, Uganda Law Society and Jackson Kalugaba versus the Attorney General. This is not justice. It is judicial lynching rally, stage managed at the scene of the crime with the direct command, responsibility of the executive and active complicity of the judiciary. The evidence of interference is overwhelming and brazen. On 7th April 2026, that is after 5 days from the occurrence of this event, of this massacre, Principal Judge Jane Francis Abodo publicly declared that the President says the case must be handled and directed the judiciary to test the mobile court directive by taking the court to Gaba and handle the case there and handle it fast. Those were the words of the principal judge quoting directives from a fountain of honor. Minister of State for Youth and Children Affairs, Honorable Balam Baruhagara, went further than this, addressing the Uganda Broadcasting Corporation, UBC, on 4th April 2026, that is 2 days after the incident. He dismissed human rights and all plausible defenses of the terrorist, who should be charged with premeditated murder, and declared that such suspects deserve death by shooting at a firing squad in full view of the public at City Square. Those were the wordings of the minister. Very unfortunate. While representing His Excellency, President Museveni, at the memorial service held at Gaba Community Ministry Church compound on 6th April 2026, the same minister pronounced the suspect, he declared him, and he had already convicted him, as a criminal, even before his first appearance, that is, even before the suspect's first appearance at Makindye Chief Magistrates Court, which was on the 8th April 2026, where the accused was formally charged with the murder of the 4 toddlers. In a long post on X, formerly Twitter, on 10th April 2026, a day after the accused was committed to the High Court under visible harassment and dehumanization by security officials, the minister, that is Honorable Balam, yes, that name. The minister announced the precise trial modalities as daily sessions from 9 a.m. to 4 p.m. starting on Monday tomorrow, 13th April 2026, with a limited seating of 1,000 people, giant screens and speakers for public viewing, live broadcasts on television, and the entire spectacle at the scene of the crime. The judiciary's own communique unsurprisingly came a day later confirming it will stream the proceedings live to enable a wider audience to follow, while restricting access through a categorization system that prioritizes religious leaders, affected families, local leaders, and media, precisely the constituencies already inflamed by ministerial statements. This is not public participation. It is the weaponization of public grief to predetermine guilt. The minister's memorial service rhetoric, the president's direction, and the judiciary's eager compliance have fused the executive, the community, and the court into a single lynch mob. The presumption of innocence guaranteed by Article 28, Sub-Article 3, Paragraph A of the Constitution, Article 7, 1B as well, of the African Charter on Human and People's Rights, also known as the Banjul Charter, and Article 14.2 of the International Covenant for Civil and Political Rights, ICCPR, has been publicly executed before any evidence is tested. The ULS was neither consulted nor invited to participate in this rushed constitutional experiment. We do not support it. We reject it. In 2002, the ULS successfully petitioned the Constitutional Court to declare that even field court-martial proceedings conducted in the heat of public outrage violated the right to a fair hearing under Article 28 of the Constitution when they denied the accused adequate time and facilities to prepare a defense, an independent and impartial tribunal, and the right to appeal. The court held that the Constitution applies fully to every judicial process, military or civilian, and that it is not possible for Uganda military courts to be independent and impartial given the current laws and the military structure within which they operate. The same principle applies with even greater force here. A mobile court summoned to the crime scene at presidential command, surrounded by mourners, pastors, and live cameras, cannot possibly be independent or impartial. It is structurally incapable of delivering justice. The UN Human Rights Committee, in General Comment number 32 on Article 14 of the ICCPR, is explicit. The right to a fair trial serves as a procedural means to safeguard the rule of law. It demands an independent and impartial tribunal, equality of arms, adequate time and facilities for the preparation of a defense, and protection of the presumption of innocence from prejudicial pretrial publicity or public opinion. Public hearing may be restricted for reasons of morals, public order, or the interests of the private lives of the parties, precisely to prevent the kind of mob atmosphere now being engineered. The African Commission's 2003 Principles and Guidelines on the right to a fair hearing, to a fair trial, and legal assistance in Africa reinforces this Judicial bodies must be free from inappropriate or unwarranted interference with the judicial process. And no accused person may be tried by a tribunal whose independence is compromised by executive direction or population pressure. The judiciary's ill-guided embrace of public participation in this matter fans the flames of judicial lynching. Notwithstanding the powers of the Chief Justice under Section 5 of the Trial and Indictments Act, Cap 25, or the Constitution, Operation of Mobile Courts Practice Directions 2026, the venue of any trial is a matter for judicial determination by the presiding judge. In fidelity to the sacred principles that justice must not only be done, but must manifestly and undoubtedly be seen to be done, the High Court is obliged to transfer proceedings to another place where an impartial trial cannot be heard in the original venue. So we ask, how can Justice Alice Komuhangi Kawuka This is what we ask. How can Justice Alice Komuhangi Kawuka credibly determine venue impartiality when the judiciary has already converged with the executive to announce Gaba Community Church grounds before hearing a single submission? That is our question. The site was selected after a minister's directive, inspected by the deputy registrar, and advertised as historic before the file reached the judge. That is not judicial determination. That is autocratic instruction. When the executive chooses the dock, the judiciary builds it. The defendant is already in chains. Article 28(1) dies not in the judgment, but in the venue notice. By relocating the High Court to the church grounds where the victims were mourned, by installing screens for the crowd, and by scheduling a one-week fast-track trial immediately after committal, the judiciary has transformed a solemn criminal proceeding into a public spectacle. The accused, already labeled a criminal by a serving minister and targeted for a swift and tough punishment, cannot possibly receive the fair trial guaranteed by the Constitution. Defense counsel will be forced to prepare under the glare of national outrage, with the entire nation watching live. Any perceived lenience will be made with accusations of judicial weakness. This is not access to justice. It is mob justice disguised in decorum. Why should this be of concern to Ogola in Busia, Okero in Kitugum, Bwambale in Kasese, and Namukasa in Masaka? This is not merely a single trial. It is a precedent in the making. The manner in which this case is conducted will define the template for future high-profile prosecutions. If constitutional safeguards are diluted under the pressure of public outrage and executive direction, such dilution will not remain exceptional. It will become the norm. We are not persuaded nor should any rational observer be that Christopher Okello Onyum will receive the assurance of a fair trial. The convergence of presidential directive, ministerial pronouncement of guilt, and a venue chosen for its emotional symbolism creates an environment of inevitable bias. The separation of powers, independence of the judiciary, and the rule of law itself are under direct assault. This is something we have always been singing all the time. The independence, the separation of powers, the independence of the judiciary, and the rule of law itself are under direct assault. The ULS, which in 2002 stood against executive overreach in the name of speedy justice, stands gallantly again against it today. We call upon the Chief Justice to immediately withdraw the mobile court directive in this case, to conduct the trial in the ordinary High Court premises in accordance with established rules of procedure, and to reaffirm that the judiciary serves the Constitution, not presidential instructions of public sentiment. The victims' families deserve justice. The rule of law demands it to be delivered fairly, impartially, and without theatrical flourish. Anything less is not justice. It is vengeance dressed in judicial robes. The Uganda Law Society will continue to monitor these proceedings and will not hesitate to take all necessary legal steps to defend the constitutional order. Issued by the Uganda Law Society Council this 12th day of April 2026 at ULS House, Kololo, now and today. Thank you. A brief translation into Luganda. Kakati kino kye kiwandiiko ekiraga obwennyamivu n'obutali bumativu bw'ekibiina ky'abalooya nga kikulemberwa akakiiko akafuzi ku nsonga y'ekkooti egenda okutuula eggaba okuwoza omusango gw'omuntu mwenna gwe mubadde mulaba ku TV ne mu mawulire gwe bayita Christopher Okello Onyum eyatta abaana bana. Ensonga eno yabeerawo nga bbiri, okuwuliriza omusango ogwo kugenda kutandika enkya nga 13 nga waakayitawo ennaku 11. Tuzze tuwulira ebintu bingi ebyogerwa abakulembeze bye tulowooza nti tebyandibadde bituufu kuva mu bakulembeze abo. Ekisooka kye kya minisita atwala ensonga z'abaana Balaam Baruhagara eyavaayo omwami ono n'amusalirawo y'omusango yamuyita namutujju. In fact mu bigambo bye bu video tugenda buplayinga nga maliriza wano yagamba abantu bwe bati basaana kuteeka ku Freedom Square ne babakuba amasasi ne bafiirawo. Ekyo nno kyava mu minisita. Era ne tuwulira ebigambo okuva mu omukulu atwala abalamuzi ab'ekkooti enkulu Principal Judge Abodo Jane Francis nga naye agamba mu bigambo bye nti pulezidenti w'eggwanga yatugambye ensonga eno tugikoleko mangu, n'olw'ensonga eyo sipiidi eno yonna yonna gye mulaba eriwo lwakubeera okulagira n'ebiragiro bya pulezidenti. Tuzze tukinnyika nga tukyogera lunye nti ekitongole ekiramuzi kibeere nga kyeteŋŋenena bakirekere okwemalirira kwakyo okukiweebwa ssemateeka. Naye enfunda nnyingi tuzze nga tulaba abakulembeze president abakulu abo abagwa mu kkoweeri erya executive baminisita nga bavaayo okulagira ekitongole ekiramuzi n'okubaako bye babagamba okukola, ne twekanga ng'ate ekitongole ekiramuzi tekiwadde ensala yeeteŋŋenedde nga bwe kirina okukolebwa mu ssemateeka. Kale nno tubeera tugamba nti emisango gino gyandiwuliddwa mangu. Ku ssaawa eno kye bagezaako okukuwa ggwe munnayuganda yenna ali eyo, oli musanyufu kuba olowooza nti ekkooti ekoleddewo, abaana battiddwa, mu nnaku 10 omuntu bagenda muwozesa. Mu mateeka tulina ekintu ekigamba nti ensala y'omusango erwawo omuntu obeera kwegamba tomuwadde kulamula kulungi. Kyokka ate era bw'oyanguya empoza y'omusango sitiwi leero omuntu oba tomuwadde nnamula ya musango nnungi. Abantu battibwa nga 2, omusango gugenda kuwuliribwa nga 13. Mu mateeka gwe nga munnayuganda olina obulumi kuba walabye ng'omusajja onatta abantu bye bitambula mu mawulire, naye omuntu oyo ayina eddembe okuwolerezebwa puliida, ayina eddembe okutegeka omusango gwe. Kale nno twebuuza, bapuliida abagenda okuwolereza omuntu ono bagenda kukikola batya? Bapuliida tutera okubeera n'obuzibu bwe tuwolereza abantu bano, abantu abakulaba bo baba naawe bakusalidde dda omusango, naawe olinga omutemu oyo. Allegedly omuntu oyo ababeera bali mu muwozesa bazuula oba mutemu. Puliida aba akola ssemateeka kye kimuwa okukola. Kati teeberezaamu mu lujjudde lw'abantu, puliida agenda kuwolereza atya omuntu ono ng'akola ssemateeka kyamulagira okukola ng'abantu bamuŋŋoola? Mu bantu abo bonna abajjudde already abaasalidde dda omuntu ono omusango. Kale nno amateeka mangi nnyo agazze googera ku bintu bino. Ffe ng'ekibiina ky'abalooya olw'okubeera nga twesigama ku nnamula y'amateeka n'enfuga y'amateeka nga gagoberebwa obulungi, tulowooza nti kino si kyakugoberera mateeka bulungi, era y'ensonga lwaki tuvuddeyo nga tuwakanya ensonga zino, era tusaba era tuteeka Ssaabalamuzi ku nninga ebintu bino bye yagambye nti abantu bano omuntu ono awolerezebwe mu lujjudde abisazeemu, omuntu ono ayite mu mateeka. Amateeka agalina okugobererwa gagoberebwe bulungi ewatali kyekubirira. Ffe tulowooza nti kuno si kuwa muntu